September 10, 2012 is just as done dirt cheap. Heading down to the courthouse for a hearing today regarding a motion for security of costs that the city of Fredericton has filed. And what they're seeking is an order of the court that I have to pay about $6,000 in costs before I can have my appeal heard. Now I'm appealing a decision. A judge of Court of Queen's Bench in New Brunswick, Justice Clendenning. Clendenning made a decision which I believe is full of errors. It's full of errors in fact, errors in law. I believe she abused her discretion in that decision in awarding over $10,000 in costs against me. What's amazing is she even ordered, as an example, I believe it was $3,000 in costs awarded to two self-represented litigants who did nothing but copy a motion that the city filed. Now, they did absolutely no work whatsoever. To just take someone else's motion and just replace their names with your names and ask for the exact same relief is not merit. That's just copying and basically pasting. Yet, despite that they did not actually do any valid work on these motions, the judge awarded $3,000 of costs in their favor, which doesn't make any sense. So I'm appealing the decision. I filed the appeal already. It's all been served, and just finalizing going through the appeal stages right now, like finalizing the documents so we can move forward to appeal. Now, what the city of Fredericton has done, and specifically Leanne Murray, the solicitor representing the city of Fredericton, and other Fredericton Police Force members, including the Chief of Police Barry McKnight, is she filed a motion where she's demanding costs to be paid in advance. And the practice is to have 2/3 of the cost paid in advance, so that, and only after I pay those costs can we move on to appeal. And if I don't pay those costs, then I would be either deemed to have abandoned my appeal and or the original action would be stayed. So it's an interesting little legal maneuver. It's just one more step in the process where I'm being blocked. This is, I'd say it's highly unusual, because in searching CanLE, which is the Canadian online legal database, I was only able to find no more than 12 references to a motion for security of costs, and most of those were rejected. So it'd be quite amazing today if the judge actually grants this motion for security of costs, considering that in the affidavit I filed in response to this motion, I explained a lot of the situation by affidavit. It's considered evidence, and the court is going to have to accept it as fact. Unless there's contrary evidence provided, then the judge would have to make a judgment call and decide which one of the two versions are true. So we'll see how it turns out today. I plan on relying on my submissions and demanding the judge take judicial notice, which means the judge is supposed to take notice of every common fact that the judge should already know, as well as rely on the judge's basic understanding of the law and understanding of legal procedures and such, so that if there's some argument that I missed, then the judge should already be aware of it and should consider it anyway. Also, it should be worthy of note that the Canadian Judicial Council has provided several written documents, one of them specifically stating that judges in the judiciary should basically provide a little bit extra service for self-represented litigants, not to the point of providing legal advice, but to the degree of causing a fair and even proceeding. So thank you for listening. This is Justice Done Dirt Cheap, Fredericton, New Brunswick, Canada, September 10, 2012, going into the Justice Building in preparation for a motion. Thank you.